point.
Louis Gainor, criminal defense attorney, when you have a case, you've got to learn all this stuff. You need to be as up to speed as any expert you put on the stand, right?
You do, because then you run the risk of looking like an idiot in court, and I've done that plenty of times. I hope not to repeat it. For blood stain analysis, the basic science is that blood is comprised of three components. You've got red blood cells, white blood cells, and platelets, and they're suspended in plasma. And this liquid, when it comes out of the body, it's controlled by gravity and physics. It actually forms a perfect sphere, and that blood droplet will travel through the air in a sphere. When the sphere makes contact with the wall or the floor, that's when it creates like a teardrop shape. And that's where the scientists will apply mathematics and physics to determine basically and triangulate the source of that blood and the impact velocity, such as low velocity, medium, and high velocity. That's basically the science you're looking at. It's really math and physics.
All right, let's take a look. Louis Gainor, the blood doesn't lie. Is the blood lying in this case?
Well, it may not be that the blood doesn't lie. It's just that the blood supports a theory. And a theory is only as good as its assumptions. And so you could have blood splatter on a wall, and you could use physics and mathematics to say, well, the droplets would form this type of shape, and we can attribute that to this angle of a blow, and the origin was so many feet away. But it doesn't tell you why the blood is there. It doesn't tell you who put the blood there. And that's the problem, is that it gives you a result to a question that you've never really formed. Which is,
okay, are you convinced, though, Louis? Are you convinced that this little girl was murdered in that apartment? I'm not saying by who, but do you believe she was murdered there?
I believe she was murdered, but I'm not sure if they can prove beyond a reasonable doubt who did it, because there's two suspects here, right? Why has no one talked about the fact that the grandmother may have done so, or another family member? And this is not to cast a pall over that family in the time of grief and suffering, but the fact is we have to ask these hard questions. This isn't a time where we're going to let sympathy become a higher priority than finding the truth.
All right, Louis Gainor, if you were representing this accused killer facing the death penalty, who do you want on that jury? Do you want young single men?
Well, you got to be really careful with selecting a jury in domestic violence cases, because there are dynamics at play that you won't find in other cases like a robbery or a DUI involving death. Primarily, you have this dynamic with women on the jury. Women usually are the best jurors you could have. It's actually a fact of life that women think about other people and men don't. Men think only about themselves. So women usually make great jurors because they'll stop and think, well, I don't know if I want to do this to this person, or convict them and send them to jail. But in a domestic violence case, women, it's been shown, scientific studies have shown this, statistical studies, surveys, and so forth, have shown that women who sit on a jury and they have a woman who is the victim of domestic abuse, they become judgmental because they start to think to themselves, well, what would I do if I were in her shoes? Would I go back to the abusive boyfriend? No, I wouldn't. I would just leave. And so you have this strong tension when it comes to getting women on the jury. If there's no rule in criminal defense, is if you have a client who is an attractive young woman, put men on the jury, because men are simple. I mean, you can figure them out that easily. Just put men on the jury. If you've got an attractive defendant, usually they're going to lead towards not guilty. But women can be unpredictable as members of the jury. There's this reverse psychology, and it's dangerous for your client. So if I'm picking that jury, honestly, I don't think I want any women on the jury. I want it only to be men.
And you know, Louis Gainor, the concern for the state is you've got a convicted killer who is going to end up going to prison, and he's got millions and millions of dollars. So if this guy breaks out of this monitoring device, he could just take off forever.
You know, I've represented these multimillionaires before, and they all drive me crazy because they do two things. Number one, they never talk to you directly. They have their lawyers call you. So their people talk to your people. And number two, they never follow the rules. They always violate the rules. They get to court and they don't have to follow their sentence because those are rules that apply to other people, not to me. That's basically every time I represent a client like that, we have this problem. So I'm not surprised at all. And so it's also typical that they would hire an independent forensic expert just to talk about this ankle monitor. I mean, that's probably the first time in history that somebody has hired an expert for the purpose of a bond hearing. But I will say this. We have the reason we have the law is because we don't want people making judgments on people because they happen to have a lot of money. Whether you are poor and don't have a dollar to your name, or you have multi-millions, they should both be treated the same. So the law, when it comes to bond, is that bond is supposed to assure the appearance of the defendant for court dates. That's it. It's not meant to punish people. It's meant to ensure they get to court. So if he can post bond, even if it's $7 million, we're going to treat him just like everybody else. If it's an accidental violation of the ankle bracelet, that's possible. I mean, the fact is, most of these monitoring systems are run by sheriff's departments that don't have any money, and these devices are worn down, and the battery life is 20 minutes. So they got to charge them every half an hour. So all I would say this is that he is entitled to a fair hearing on his bond, and the fact that he has so much money should not be held against him.